All right. So as it has been our custom the last few weeks, we will begin tonight with, start from current slide. There we go. With the question, what theme or idea caught your attention or surprised you in this week's reading? I think this was the largest single selection of reading for any of our gatherings. And so I know there's a lot to cover here, and I am not going to try to go section by section tonight the way we have in previous weeks. Instead, we're going to look at kind of the overarching themes and also a bunch of definitions of some of the very unique and specific vocabulary that we use when it comes to our process of church discipline. So with that, just as our process for tonight in mind, I'd like to hear what reflections you have, what caught your attention or surprised you in this week's reading. And I will invite you to share rather than going around the room like we often do, because it is not everyone isn't in the same order in our Zoom windows. So we'll just go in the order in which I see you on my screen, starting with Justin, if you would, please.
Sure, yeah. So, hi, my name is Justin. What caught my attention this week was around how much of this is new, especially like the back half was like all bold text. And I guess I'm new to the PCUSA. I thought a lot of this like sexual misconduct stuff would have been in place like 20, 30 years ago. So I was just kind of shell shocked when I was going through it, but I'm excited to learn more.
Yeah, thanks for lifting that up. At the last General Assembly, the entire, what we used to call the Book of Discipline, was changed for this totally rewritten and overhauled church discipline section. So this part of the Book of Order, this last part, is entirely new in its present form. Obviously, there were a lot of precursors and a lot of stuff was present in some form, but this was a massive overhaul that was just adopted. So thanks for lifting that up, Justin. James, would you please share next?
Yeah, I was fascinated to see how we have a sort of legalistic structures in the church, like more or less like a court or that form of like legal documents. I didn't know of this one until I started reading. Like we have well laid down structures that anyone who feels like offended or who feels that he has some concerns to be addressed, like structures that you can follow to get your issue settled on for you. And I'm like, usually I think of the session. If you have any problem, you just go to the session. Once it's a Christian organization, okay, you get to a session and everything is sorted out and it should end there. But I didn't know that there's that kind of long legalistic like processes that one can go through to get certain issues addressed. So like I think it's my first time of seeing documents like this. So I think it's a good thing, and I would take my time to like study it and see like the nitty-gritties of the document and know what exactly uh, they are seeking to teach us as far as addressing grievances and concerns are concerned, if I should say. Yeah.
Thank you, James. Yes, it is a very detailed process. And as I hope you saw throughout, all of it is meant to restore and restore trust and build up the body of Christ. But of course, as much as we might wish that to be the case, easily just by going to the session, even with local issues, sometimes that's not enough. So we have a clear process, and I hope it will be a gift. My first hope is that you never need it. This is the part of the Book of Order that we hope you never have to read again after this class. But my follow-up to that is that I hope that if you do, it will serve you well, whatever is going on. Thanks for sharing. Jiyoung?
Yes. One thing I was impressed impressive by the SD 7.1603. I was thankful that there is the law of restorative justice. And I remember the Bible verses that don't sue the church thing and outside, I think. And then, but thankfully, this D section, D part, I realized that PCUSA have a detailed laws, even restorative thing. So I like it.
Thanks for lifting up the restorative justice section, Jiyoung. Yeah, that is especially new to be laid out in such a specific fashion. And while it's not appropriate in every case, it does give us a pattern for a way to bring about restoration when hearts and spirits are in that place, right? Thank you for sharing that. Let's see. Right, Nora?
Hey everyone. Something that already my colleagues mentioned about how elaborated the section is. It happened that I read some of the some sections in the Book of Order like a few years ago, but I never pay attention to this section. So this is my first time to read through, and what you said about the new parts that were, added to it explained my surprise, why I got surprised, so how elaborated this section is. So it was good. Was a good treat. Thanks.
Thanks for sharing, Nora. So I think it's interesting that about 12 years ago, when we got the new form of government, it really consolidated and condensed and shrank that section of the Book of Order. I don't think that's the case for church discipline, the new section of church discipline. It actually expands and elaborates more. So that just speaks to how our polity is constantly responding to the movement of the Spirit and the needs of the church in different times. Johnny.
Hello, I didn't realize I was already unmuted. Anyway, I think I'm just still kind of processing the fact that we have this section and just reading it in such detail. Obviously, it's a good thing that we have this process in order in case something happens, but also just it's so detailed. It's also very legalistic, and a lot of that language I can't focus on it. I can't read it. So that'll be fun to do during exam time is the discipline section. Something that I did think about actually was I'm grateful to be part of a church that has this kind of help for when bad things happen. Like I think about independent churches who are only responsible for themselves. And first of all, how easy it is to just sweep things under the rug, like if bad things happen in a church setting. Or also, on the other hand, if you have a church that wants some kind of discipline, some kind of reconciliation, like a lot of churches are responsible only for themselves. And I think that would be a really stressful thing to deal with. So I'm grateful that, God forbid, I'm ever in that situation to report something. I have a presbytery to call and be like, help me figure out how to fix this. So, yeah.
Absolutely. One of the gifts of church discipline is that we do not walk through this process alone, whether it's a specific council or an individual. Amazing Grace.
Yeah, I will not on my video, but you can hear my voice.
Yes, we can hear you. Thank you.
Yeah. So I was just telling someone that about Presbyterian Church, I see that there is order, there is orderliness. And it's a church that one can really depend on in terms when there is crisis. So unlike some churches that when you are in crisis, you are on your own. When you are in need, you are on your own. Like this week, I needed to complete my ordination process for an inquiry to become an inquirer. And I realized that the money I'm supposed to pay is split into pay part of it, my church will pay, and then the presbytery will pay. So this gives me a sense of belongingness that, yeah, I belong to this place and these people look after. So I just love the way the church is structured to take care of everybody.
Thank you, Amazing Grace. Yes, the church is structured to take care of everyone. And when we live into the structure most faithfully, it succeeds, right? Morgan.
Hello. I can think about, I've been thinking about two things. One, I was thinking about filing an allegation and the portion that was talking about sexual abuse, and how that there is not like a limit on that, like a limit does not apply for that. And it's just something I appreciate.
Yep, no statute of limitations on those allegations. Yeah.
Like, good. And then also I think similar to Katie, there I know of an issue in a church that's like a more congregational church, and I where a pastor was committing all kinds of abuses on the congregation and outside of it. And it made me, reading this just confirmed how good it feels to be a part of a denomination that I don't think those things would fly at all. There's a very clear path where this person would not be able to be in leadership and doing the things that they're doing. So kind of both of those things.
Thank you for sharing, Morgan. One thing I noticed in my reading of church discipline, preparing for this class, was that the stated clerk of the Presbyterian Church USA has to keep records of ministers who are under investigation or under a temporary period of discipline as part of a restorative process, but also ministers who have, as a part of a disciplinary act, have had their ordination revoked, and that national reporting practice that's new, hopefully, is something that will help keep more people safe.
Yeah, I feel like that's so necessary because it's easy if they're to not have that, to be able to bounce around from place to place and keep causing harm.
Absolutely. And we really try to avoid that in the PCUSA. We are not perfect by any stretch of the imagination, but it's something we're at least mindfully trying to work on. And last but not least, Dr. Yu, what would you like to lift up that you noticed?
Oh yeah, hey. So for me, I really like D10301, Purpose of Church Discipline. I do think the one thing is, it does seem to me as should say the purposes of church discipline are rather than is, because there are 8 bullet points. So that is kind of, I thought just on a, the editor in me was like, this is a little odd. But I really do. I like that early on it really spells out, here's why we do church discipline, from honoring God, the first one, to restoring unity, the 7th one, and to securing just, speedy, and economical determination in that last 8th bullet point. So that really stuck out to me as a good theology of PCUSA church discipline. But what do you think, Pastor Marilyn? Is it right? I guess it is, because it's in bold and all that. But I think it's wrong grammatically, anyways.
Yeah, so I know that when you're kind of putting together formal writing like this is an acceptable grammatical, but I think I would have preferred the plural form myself. So, and I did vote for this and I didn't catch it. So I'll own that more correction is always appropriate. And I think that, if if we're engaging in a process of discipline, all of these need to be kept to the forefront of the actions and practices and discernment of everyone involved, right? D-1 really is the foundations section for church discipline, not unlike the foundations of Presbyterian polity, which we went over in week 1. And it is, there we go. And it is incumbent upon us as members of the Presbyterian Church USA, whenever we are engaged in a remedial or a disciplinary case, at the very beginning, if a case has gone to trial, at the very beginning of the case, one of the things that is required, you know that for any meeting of any council, it is required that we open with prayer. For the beginning of a trial, it is required to open with prayer, and it is also required that we read aloud the preamble to church discipline. So I would like to invite us to engage in that practice as we begin our discussion of this section of church discipline. I would like a different voice to read each section. So there are 6 sections. One is very, very short, but not everybody has to read. So if you are willing to read a section, raise your hand and I will name out who's going to read what in what order, and then you'll just read it as it comes. When it's your turn, you'll just read it as it comes across on the screen, because I've got it all in my slideshow. So who is willing to read for us a section? Visibly raise your hand for me. I see James, Justin, Johnny, Nora, and Morgan is great. Okay. So we will go in that order. James, if you will read D-101. Justin, if you will read D-1.0201. Johnny, if you will read D-1.0202. Let's see. Nora, will you read D-1.0301 and 1.0302? Okay, you'll read all of D-1.03. And then Morgan, if you would please read D-1.04. So let us hear together, friends, the preamble.
The power vested in Christ's church. The power that Jesus Christ has vested in his church. A power manifested in the exercise of church discipline. Is one for building up the body of Christ, not for destroying it, for redeeming, not for punishing. It should be exercised as a dispensation of mercy and not of wrath, so that the great ends of the church may be achieved, that all children of God may be presented faultless in the day of Christ.
And then church discipline defined. Church discipline is the church's exercise of authority given by Christ, both to guide, control, and nurture its members, and for their correction and restraint of wrongdoing. The church's judicial process does not exist as a substitute for the secular judicial system, but to do what the secular judicial system cannot do. The Constitution of the PCUSA is infused with principles and standards to which all active members of congregations and ministers of the Word and Sacrament voluntarily submit. And
Limits
then,
of church discipline. Sorry. Limits of church discipline. Church discipline alone is not adequate to mediate intrinsic differences of theology, polity, policy, power, or trust. Broader issues of conflict are also addressed by constitutional amendment, mediation, administrative review, and administrative commissions. Church discipline through the judicial process shall be used wherein individuals or councils of the church are unable to bring about settlement of issues, or when such settlement would be unwise, unjust, or ineffective, and have determined after prayerful deliberation that judicial process is necessary to ensure that individuals or councils are held accountable for their actions or their inactions.
Purpose of church discipline. Thus, the purpose of church discipline is, first, to honor God by making clear the significance of membership in the body of Christ. Two, to preserve the purity of the church by nourishing the individual within the life of the believing community. Three, to pursue and reveal the truth. Four, to achieve justice and compassion for all participants involved. Five, to correct or restrain wrongdoing in order to bring members to repentance and restoration. Is it still me?
Purpose of
Oh.
church discipline. D10301. Purpose of church discipline. Thus, the purpose of church discipline is to uphold the dignity of those who have been harmed by offenses, to restore the unity of the church by removing the causes of discord and division, and to secure the just, speedy, and economical determination of proceedings. Shall I continue?
Please.
Yeah. Due process. In all respects, participants are to be accorded procedural safeguard and due process consistent with these principles of church discipline.
The traditional biblical obligation to conciliate, mediate, and adjust differences without strife is not diminished by the church discipline. Although these rules describe the way in which judicial process within the church shall be conducted, it is not their intent or purpose to encourage judicial process or to make it more expensive or difficult. Those contemplating the use of judicial process shall recall the Bible or the biblical duty to come to terms quickly with your while you are on the way to court. Matthew 5:25. They shall attempt prayerfully and seriously to bring about an adjustment or settlement of the issue asserted and avoid formal proceedings under judicial process unless, after prayerful deliberation, it is determined to be necessary to preserve the peace, unity, and purity or accomplish the purposes of the church. Nor shall this duty to consider other forms of resolution end upon the commencement of judicial process.
Thank you all for lending your voices to this section of our Book of Order. So let's think about this preamble a little bit. What values are explicitly named in the preamble to church discipline?
Trying to heal before you get there.
Mm.
Like working conflict resolution.
Absolutely. Conflict resolution, when possible, heal before you get there. Rooted in scripture.
I feel like every bullet point in 1.0301 is kind of its own value about truth and justice and honoring God and the purity of the church, dignity.
Absolutely. We could call these the great ends of church discipline. Any other values anyone would like to lift up?
To build the body of Christ.
To build up the body of Christ. Absolutely. That's a core one. Particularly highlighted by what this is not, right? Not for punishing, not about wrath, but about redeeming and mercy. So I told you that The Book of Order requires that the preamble be read aloud at the beginning of any remedial or disciplinary trial. And what do you think the value of that practice is? Why might that be a requirement that the Book of Order has included?
I think of it as kind of an extension of the prayer. The prayer I feel like is a spiritual opening, and the reading of the preamble is a judicial opening. Like, this is why we're here. It mentions the values that we just talked about, kind of keep everybody in check and to move forward with like Christian composure, so to speak, as best you can, you know, depending on the situation, depending on the trial.
So something to help us conduct ourselves with Christian composure. I like that idea. Absolutely. Would anyone like to add to what Johnny said? Jiyoung, I think you forgot to unmute.
I just read it. Sorry.
No problem. I just didn't want to miss what you were sharing if you were trying to
Mhm.
share with the class, literally.
Mm.
Okay. So I'm curious if there are any values that you heard or you think are included, but are only implied and not specifically spelled out in the preamble of church discipline. Another way to ask this question is maybe if there was another specific line or phrase that you wish you'd seen included, what is it?
I don't know why, but the thing that's floating up in me is shame, and I haven't really fully fleshed it out. There's something about like preventing shaming, like there's not being a space to shame. And I know that has to do with wrath, but wrath feels like punishment. It also should be a space to be like, we're going to intentionally shame you because we don't value you, because we don't think you're pursuing the truth or something.
Mhm.
'Cause it feels like I know that ministers of word sacrament technically vow to follow this book, so I feel like something around that would be beneficial.
Thanks, Justin. I think our culture has a lot of maybe even baggage with the word shame. There's a lot we can pack into that one word. And that is true for many cultures, not just ours. So this might be a case where a little definition and a little clarity would be helpful, redemptive even. Yeah. Anyone else? Yeah, Dr. Yu, go for it.
I mean, I think implicit is the use of economical in that eighth purpose, and it's not what the secular judicial system can do in D 10201. It's simply, I think it really is saying lawyers and the secular judicial process is very expensive, and it is not good monetary stewardship. I think that is actually pretty clearly implicit, right, in the D1 section.
Mm-hmm. Absolutely. That's a question we should always be asking as members of the church, right? What is the faithful stewarding of resources in a particular situation? And you're certainly right that the secular judicial process or civil judicial process is not cheap. So if an issue has presented itself, which might be resolved in a secular court, but which has a rightful place in an ecclesiastical court, it is cheaper and more faithful and more economical to do so amongst Christians, as it were. Yeah. Thanks for lifting that up. So back when we talked about the foundations of Presbyterian polity, we talked about how those were going to shape the rest of the Book of Order a little bit. And the Reformed notes of the church pop up again and again and again throughout, especially the form of government, but even the directory for worship. And so here we could easily argue, and in fact I would, that the entire part of the Book of Order, church discipline, is based on the note of the Reformed Church that ecclesiastical discipline is uprightly ministered, which we have rephrased for our own time, that the church nurtures a covenant community of disciples of Christ. And I'm curious, how does the preamble shape your understanding of the role of church discipline, specifically in our denomination?
I'm not sure 100% of my answer, but I'm gonna throw something in there. Kind of, it shows that there is a valid reason why we're doing church discipline. So there's a talus that's the focus of why we're doing this, and first and foremost, we're doing this in honor of God, in order to honor God. So it's one of the values that we mentioned, as well as related to what it means to nurture a covenant community of disciples of Christ. Which involves having a code of trust, a code of conduct, and all of the necessary things that should take place in order to keep the community together.
Thank you, Nora. Absolutely. The preamble tries to set the tune for how we will nurture and build up this body, and trust is just absolutely essential to that. And I appreciate how that is made clear in the preamble. And it'll show up again in the rest of the part of the Book of Order. Anything anyone else would like to add? Okay. Well, I thought it would be a really helpful thing for us to go through some of the vocabulary that is unique to our church discipline and to talk through it. So I've pulled a lot of definitions straight from the Book of Order, or I've given a few that are my own based on my reading, just to try to be a little more succinct. And so we're just going to go through those. And if you have a question about any of them as we go through, please jump in with it. Unmute yourself and just say, hey, this is my question. And we'll try to unpack anything that isn't immediately clear. So first, councils of the church. This should be really familiar language to you by now. The four types of councils of the church are the session, the presbytery, the synod, and the general assembly. And sessions conduct trials of church members in disciplinary processes. And any time later in church discipline, when you read about the Permanent Judicial Commission, their role and their work at the higher levels, at the higher councils, the presbyteries, the synods, the General Assembly, that is the session when it comes to a congregational matter. Either a session member with a session member, or a session member with a congregation member, or two congregation members where the session is trying to mediate and move through a disciplinary process. So I want to lift that up and make that really clear for us, because it's not always, the Book of Order often will just talk about the PJC, the Permanent Judicial Commission. And of course, it always spells it out, but I will use that acronym a little bit. But many of the things it says about a PJC, a Permanent Judicial Commission, also apply to a session when the session is the council dealing with the disciplinary issue. Okay. So there are two types of disciplinary proceedings. The first is remediation. Remediation is the process by which councils are held accountable to the church, to their members, and to each other. Through remediation, actions or omissions contrary to the Constitution by a lower council or entity of the General Assembly may be corrected by a higher council. One of the things we noticed, especially in the form of government, is how there's this constant accountability amongst the different councils of the Presbyterian denomination. And remediation is a disciplinary process through which that accountability is sometimes lived out. So the purpose of remediation is to further the peace, unity, and purity of the church. That should sound really familiar to you, because that is taken straight out of our ordination vows. The purpose of remediation is to further the peace, unity, and purity of the church by ensuring that the Constitution of the PCUSA is upheld, and that disputes regarding its requirements are addressed in a manner that is both fair and just to all concerned. So when we get to disciplinary cases, we will see that a disciplinary case can be brought when an offense has occurred that is contrary to the Constitution or to Scripture. But when it comes to remedial cases, they can only be brought in cases where there has been either by omission or commission a failure to comply with the Constitution of the PCUSA. So that's an important distinction as well between remedial cases and disciplinary cases. Make sense? Okay. So a few other pieces about remediation. While a remedial complaint may be filed by individuals, it can never be filed against individuals. So remedial complaints are always filed against a council, a session, presbytery, a synod, a general assembly. And importantly, a remedial complaint may not be filed against a congregation or a committee or commission of a council below General Assembly. So we can file remedial cases against committees or commissions of the General Assembly, but not of synods, presbyteries, or congregations. So for example, if there's been an issue about a committee of a session in a congregational setting somehow acting contrary to the Constitution, to our Book of Order or Book of Confessions, because that committee answers to the session, and the session has to approve and ratify all of the work that that committee does, the session is the body accountable for the inappropriate action or omission that the committee did. I see a raised hand. Johnny, did you want to ask something?
Yes, does that same logic apply when it's like a minister of word and sacrament or someone that's in power at the church has committed bad actions, so to speak? Does the complaint go against the session of the church?
So it
If a minister
depends.
of word and sacrament is accused of sexual harassment,
Right.
like,
Okay.
how
If a
does-
minister is
with that
accused of
same
sexual
logic-
harassment, that is a disciplinary case, not a remedial case.
Okay.
So
Okay,
right
we haven't
now we're
gotten there yet.
only talking about remedial cases. Yes, there's this
Okay.
really important distinction in our book of order between remedial cases and disciplinary cases. They are not the same thing and they do not serve the same purpose. So if an individual has behaved in a way which is contrary to our faith and or our constitution, right, such as sexual harassment, that's a disciplinary case. And that's not limited to just ministers of the word and sacrament. If a ruling elder, if a member of a congregation who is not ordained behaves in a way that is hurtful and disrupts the trust that our congregations and our communities of faith are supposed to nurture, that is a disciplinary case. So remediation is a case where a council has either through omission or commission somehow not acted in compliance with our constitution. It's an important distinction. Thanks for asking that. Yeah. So a session is responsible for correcting constitutional errors or omissions by its congregation. And then the higher councils are responsible for taking action, either with regard to councils to correct actions taken by lower councils or for themselves, if that makes sense.
Hey, Pastor Marilyn, real
Yes,
quick
of
to
course.
Johnny's good question about
Mhm.
remediation. And so we have 4 councils. I'm gonna take out synods and general assemblies for my question, just sessions and presbytery. Most likely, Johnny, to your point about sessions, what if a minister of word and sacrament is held liable for sexual abuse or harassment, and the session knew about and the session failed to act? A kind of sin of, I don't know if it's omission or commission, but you know what I mean?
Mhm.
Does that fall under remedial or the disciplinary process? And or you can even say the presbytery, the session trial. I don't know how it would work where the presbytery would be liable, but you know what I mean.
Yeah. So at that point, the presbytery could bring charges against the session, but we don't actually hold session like councils accountable for individuals' actions. So you would, in order to bring that case, a presbytery would have to see evidence that every member of the session knew about it and withheld that information. We do say that ordained ruling elders are mandatory reporters as far as the legal, the civil civil authorities are concerned, especially about issues of abuse or sexual abuse or harassment. So in that case, if a presbytery felt like a session had actively tried to cover up uh, a case of, for example, sexual harassment committed by a minister of the word and sacrament, I would expect the presbytery to then bring disciplinary charges against the ruling elders on the session at the time that that was committed, because that's an individual sin, even if it was an organized activity by multiple people. Does that make sense? And then that would be a disciplinary issue. And that is absolutely an issue that might come up. Yeah. It is unlikely that an entire session would actively try to cover something up for a minister. Most of the times, disciplinary cases that concern issues that have occurred within a congregational setting blow up. That is, it's this kind of a crass term, sorry, but they sort of take off, if you will, when a session member gets wind of something and isn't willing to turn a blind eye to it, and then files charges. And I know of a few different cases in which that has happened, and usually that the person, the whistleblower, if you will, the person who brings the charges, the person who files, is not the first person to know, but they're the first person to take proactive action. And usually they are the first person to find out who is familiar with our church discipline. Does that make sense? So this would be, that is absolutely a reason why church discipline should not be skipped when it comes to elder training. You hope you never need it, but church leaders, deacons and ruling elders need to know what to do and where to go if the need arises. Okay. Any other questions before we continue looking at remediation? Okay. I haven't seen any. Again, if you think of something, just unmute yourself and chime in, or raise your hand, whatever works for you. So remedial cases have come in two types. There are irregularities, which are actions contrary to the Constitution of the Presbyterian Church. And there are delinquencies, which are omissions contrary to the Constitution of the Presbyterian Church, USA. So an irregularity is an action which is an active thing, right? Something was done that was not in compliance with the Book of Order, right? So, for example, if a session approved a second baptism for a person who had previously been baptized in the name of the Father, the Son, and the Holy Spirit, right? We don't do second baptisms as a denomination. We think it takes the first time, one and done. And so that would be an irregularity. The session would have done something contrary to the would have approved an action and thereby is responsible for the action that is contrary to our Constitution. A delinquency is an omission. As you've sometimes, I'm sure you've heard about sins of commission versus sins of omission, right? This is the same thing. Irregularity is a commission, a delinquency is an omission. So I think I shared earlier this term about how there are no minutes from the stated meeting of Forsyth Presbyterian Church's session from our March stated meeting in 2023. Our clerk of session at the time did not take sufficient notes, was not performing their duties as clerk. That was not the first meeting at which we had no minutes, but it was the only one for which we were not able to go back later and reconstruct some minutes. Our lack of minutes from a stated meeting is an omission. Okay. It is contrary to the Constitution of the Presbyterian Church. Charges could be filed in that case by the presbytery against the session that I moderate because we failed to fulfill our responsibilities as regards recording the work of the body, right? So in that case, because it was the session was made aware of this oversight, the session has acknowledged that we have failed in our responsibility. We intend to include a letter to that effect when we turn in our minutes for review from last year and say, we know this happened. We can't fix it at this point. We're just asking for forgiveness, right? I do not expect disciplinary charges in this case, or I'm sorry, I don't expect any remedial case to form out of this situation, but it could. Okay. So I give those to you as two examples of actions versus omissions. Any questions about that? Great. So a complaint. This is again a technical term that we'll see in the Book of Order. A complaint is an allegation of one or more specific irregularities or delinquencies of a council. A complaint is what gets filed in a remedial case. It's not a charge like in a disciplinary case, it's a complaint. A complaint is a decision or action contrary to the Constitution of the Presbyterian Church USA, is known as an irregularity, and the omission of a failure to act on a constitutional requirement is known as a delinquency. We just covered those two distinctions. So a complaint lists the specific irregularity or delinquency in question. Parties in a remedial case. So in order to have a case, you got to have parties. You got to have folks who are somehow involved or responsible. So the complainant or the complainants, plural, are the person or persons who file the complaint. It is as simple as it sounds, I promise. The respondent or respondents is or are the councils complained against. So in my example of the loss of the lack of minutes from the stated meeting in March last year, let's say that my presbytery reviews our minutes and they don't. Let's say we weren't going to include that letter that says, "Hey, we know we dropped the ball on this thing." let's say that my presbytery reviewed our minutes, as is their responsibility, and they didn't catch this omission, and they didn't say anything about it. Well, then it is possible that a case could be brought in our synod, both against the session and the presbytery, okay? And that would be a complaint of a delinquency as regards the record keeping of the session of Forsyth Presbyterian Church and the session records review as carried out by Flint River Presbytery. It's just an example, but that is one example of where you might have multiple councils involved. Does that make sense? Okay. So the complainant is the person filing the complaint, lifting up the irregularity or the delinquency. The respondent is the council complained against. And again, in remedial cases, only councils can be complained against. Remedial cases are not carried out against individuals. Another component that a complaint must have is a request for relief. Relief is another technical term, and by relief, we mean remedy or correction requested. So, what might the remedy be to the fact that Forsyth Presbyterian Church cannot reconstruct minutes from its March meeting? If we didn't own that we have made this mistake, that we have missed this in our responsibility and practice, a remedy might look like asking us to acknowledge our lack of fulfilling our duty vis-a-vis record keeping. A correction might also be asking us to enter into our session records, if it wasn't already there, which it is, that we acknowledge a lack of records from that stated meeting held on that date. And maybe even, and they might ask us to state why, right? So relief doesn't necessarily, like it might be monetary, but but most of the time it's just trying to correct whatever has happened, if possible. And a remedial case is only appropriate in cases where some sort of relief can be secured, okay? And the relief must be within the authority of the council receiving the complaint to grant. So it is entirely within the authority of the presbytery to grant relief with regard to record keeping issues that arise, right? Because sessions are answerable to their presbytery as it regards their records. That makes sense? Okay. So items that must be included in a complaint. This isn't really vocabulary so much as just an important list. Complaints have to include the complainant, and the name of the respondent, the particular irregularity, including date, place, and circumstances thereof, or the particular delinquency, including the dates of the written request to cure the delinquency, and of the next meeting at which the respondents failed to do so. The reason for complaint of the irregularity or delinquency, a statement of facts demonstrating that the complainant or complainants may file the complaint in accordance with D-4.02060 above, and the remedy or correction requested called relief, which must be within the authority of the council receiving the complaint to grant. So when you look at these items to be included in a complaint, it really helps narrow situations in which a complaint is the appropriate response to a sin of commission or omission by a council. Does that make sense? So what happens next? There's been a complaint. Next, we form what is called a committee of council. Now, this is a different kind of council. We have council with an I and council with an E. Council with an I is the respondent or possibly the complainant. But a committee of council, SEL, is the group formed to respond. So when a council or entity of the General Assembly becomes either a complainant or a respondent, it shall designate no more than 3 persons to be a committee of council. This committee shall represent the complainant or respondent in the case until final decision is reached in the highest council to which the case is appealed. All members of a committee of council shall be members of the Presbyterian Church USA. So this is just a way to simplify the fact that, like, if a presbytery feels like it needs to make a complaint against another presbytery, both presbyteries do not need to be fully present with a full quorum at every hearing and stage of the remedial case. Does that make sense? So a committee of counsel is a group of up to 3 persons chosen to represent the complainant or the respondent through the course of a remedial case. Questions? Committees of counsel shall not include clerks of session or stated clerks. So your committee of counsel cannot include, if there's a committee of counsel formed on behalf of a session, it cannot include the clerk of session. If there's a committee of counsel formed for a presbytery, it cannot include the stated clerk of the presbytery. Those people have so many responsibilities with regard to recording and handling documentation related to the case that they may not serve on the committee of counsel. Make sense? And one of the things I hope you noticed in your reading is just how much responsibility a clerk or stated clerk ends up with in both remedial and disciplinary cases, because they are basically the vehicle through whom every official communication pertaining to the case gets passed, in order to ensure that all those communications are made decently and in order. Also, committees of counsel cannot include employees of the council hearing the case or of a higher council that would have jurisdiction in any appellate proceeding. So, for example, it would be entirely inappropriate for Flint River Presbytery's executive presbyter, who is an employee of the presbytery, the pastor to the pastors, the Reverend Deborah Chagaskis. She may not serve on the committee of counsel in any case involving Flint River Presbytery because she is an employee of the council. Make sense? Similarly, a pastor who is the called and installed pastor to a congregation with terms of call may not serve on the committee of counsel composed of session members from that congregation because, again, that is even though a pastor is a member of a presbytery, because a pastor is employed by a congregation, the pastor cannot serve on their committee of counsel. Okay. And similarly, any employee of a congregation, any employee of a presbytery, any employee of a synod, any employee of the General Assembly, whether that person is ordained or not, may not serve on a committee of counsel. The assumption is that I think that because of their employment, they could advise, they can be a resource, but they have a vested interest in a certain way, but just by nature of being employed. And so it would not be appropriate for them to actually serve on the committee of counsel to represent that body in these different remedial proceedings. Okay. So another term that we come into, and this is actually a term that we encounter both in remedial cases and disciplinary cases, is a preliminary ruling. So when a permanent judicial commission has received a complaint or has received an allegation, whether it's a remedial case or a disciplinary case, the moderator of the permanent judicial commission and the clerk either accept a case for trial or dismiss the case because in the case of a remedial case, one or more of the 5 questions in D-4.0501A are answered in the negative. Okay. So just because there's a complaint does not mean that anything will happen necessarily after a preliminary ruling. If the preliminary ruling states that this complaint doesn't actually have grounds, either because it's not been filed in the right jurisdiction, that would be a reason, or because there's, for example, no relief possible in this case. That might be another reason, or because despite the complaint being there, there's not actually any reason to think that a irregularity or a delinquency has actually occurred. For example, the complaint might actually be based on an older version of the Book of Order or a misunderstanding of the Book of Order. Make sense? So a preliminary ruling has to be issued in every case of a complaint, but that might be the end of it, right? A preliminary ruling might be, this isn't, this is erroneous, this isn't important, this is not under our jurisdiction, that kind of thing. There's also another term that comes up both in remedial and disciplinary cases. This is a stay of enforcement. This is a written instruction from the Permanent Judicial Commission or the session having jurisdiction that orders suspension of a decision or an action until a complaint or appeal is finally determined. So let's say that a remedial case has been brought, the complaint has been found to have grounds, and there's been a trial in the remedial case, and relief has been a process for relief has been provided as a result of that judicial process. Are you with me so far in this hypothetical? Okay. At that point, if the respondent counsel says, we don't think we should have to comply with that decision until, because we're going to appeal, so we don't want to provide relief yet, that they would request a stay of enforcement. So a stay of enforcement just says there's going to be there's another step that we have to resolve first before the relief that has been ordered will actually be carried out. So that would be an appeals process. Let's say a presbytery disagreed about a case that was brought between two sessions. Those sessions could appeal their case, a remedial case, to the synod's Permanent Judicial Commission. But if one session had been ordered by the presbytery to provide relief, the session that was ordered to provide relief could request a stay of enforcement until the appeal at the synod level had been heard. Make sense? Technical terms here, y'all. You're hanging in there with me. Thanks. All right. Citation. This is another term that we encounter both in remedial and disciplinary cases. Think of a citation like a legal subpoena. A citation is a written summons to appear at trial for parties or such witnesses as either party may request. A citation shall be signed by the moderator or clerk of the Permanent Judicial Commission and served by the stated clerk of the council. And in the case of the session, that will be the moderator of the session and the clerk of session, and then served by the clerk of session. Makes sense? Only members, this is a very important distinction, however, between subpoenas and citations. Only members of the Presbyterian Church USA may be cited to appear. So let's say something, some sort of remedial case has been brought concerning record keeping about councils, and another congregation in the area might need to be a witness for some reason. Don't know why. Maybe they share a building. For example, Forsyth Presbyterian Church shares its building with Grace United Methodist Church. Maybe the administrative board of Grace United Methodist Church might know something about the records of Forsyth Presbyterian Church. That's a possibility. But no one at Grace United Methodist Church may be cited to appear in a case in the PCUSA. They can be requested, but they cannot be cited. They can't be required to show up. Only members of the Presbyterian Church USA may be cited to appear. Persons who are not members of the Presbyterian Church USA and expert witnesses, regardless of their denominational membership, may be requested. And I would encourage anyone who had been requested to appear to do so, because clearly the council investigating the situation thinks they have some information that would be helpful in the case. And I would take it as a token of building up the body of Christ with a cap, and the church universal with a capital C, if they would show up, but they're not required to. And that's because there can be disciplinary proceedings taken against a member of the Presbyterian Church USA who is cited to appear and refuses to show up. So just like in the civil legal world, if you are subpoenaed to a court appearance and you don't show up, there are legal ramifications of your lack of attendance, right? Same thing goes if you're a member of the Presbyterian Church USA. So that's an important distinction about citation. And if any of you ever receive a citation, a written summons to appear at a trial, it is incumbent upon you to do so to the very best of your ability. And it is important that you respond in writing to the citation. Accommodations can be made if you can't travel to the place where the trial is being held. We now have provisions for you appearing electronically to give witness or testimony. And you might also, if you're not able on the date of the trial to appear, you might those managing the proceedings might ask you to provide a written statement instead, but you need to respond in writing to a citation in order to avoid becoming the subject of a disciplinary investigation yourself. Make sense? And I would like to assume that everyone would want to faithfully respond to a citation from a counsel, because participating in our discipline is what we have or will promise to have promised or will promise to submit to as part of our ordination. So just bear that in mind. Council, again, COUNSEL, like committees of council, but this is now a distinct term because this is not the committee of council, this is council. Council is representation. Council is like an attorney, but it does not have to be an attorney, and it need not be a paid representative at all. However, counsel shall be a member of the PCUSA. Okay. No member of a permanent judicial commission shall appear as counsel before that commission while a member. So it is not enough to recuse. If you are a member of a PJC, a permanent judicial commission, say for your presbytery, and a disciplinary case is going on in your presbytery, and you are asked to serve as counsel either to the accused or to the accuser. It is not enough to just recuse yourself from serving on the PJC for that trial. You have to resign from the PJC entirely. Okay, are you with me? Cool. And there are a lot of very specifically spelled out procedures for how to fill seats on a PJC if people recuse themselves from a specific case or resign, for example, to serve as counsel. So if you're ever in that situation, the presbytery will figure out how to fill out the PJC so that it has a quorum, so the work of the proceedings can continue, but you can't be on it for that and anymore. And I could not tell you precisely why, but as with everything, every rule exists because at some point somebody broke it. All right. Evidence, again, technical term. Evidence is any number of things, including oral testimony of witnesses. For example, someone who has been cited to appear. It may include records, and by records, we mean official records of the church, records of church councils, right? It may be writings, material objects, or other items presented to prove the existence or non-existence of a fact. This is a really broad definition. Evidence must be relevant to be received. And no distinction should be made between direct and circumstantial evidence as to the degree of proof required. So as I'm sure you can imagine, cases can get very detail oriented, and a lot of evidence might be needed. And it may not all be obvious, whether it's direct or circumstantial. But it is all, whether it's direct or circumstantial, it should all be subject to the same standards of proof required. Does that make sense to everyone? I'm seeing some nods. Okay. Preponderance of evidence. So this is kind of what is the legal term that this parallels to? I had it on the tip of my tongue and now I can't remember. Maybe it'll come to me. Anyway, a preponderance of evidence is the term. This is the standard that needs to be met in order to find in a remedial case that a delinquency or an irregularity has occurred, and in a disciplinary case that a charge, that an offense has been committed. So this is our standard. We need a preponderance of evidence. Such evidence as, when weighed with that opposed to it, has more convincing force and the greater probability of truth. Okay, this is the measure provided by the Book of Order for how you judge in such cases. So now we've already switched gears a little bit to terms that we'll see in both remedial cases and disciplinary cases. Now we're going to switch gears and think about the disciplinary process. So remember, disciplinary processes apply to individuals. Remedial cases apply to councils. So the disciplinary process is the process by which active members of congregations and ministers of the word and sacrament are held accountable to the church and to each other, and may be censured for an offense for the purpose of restoring the wholeness of the body of Christ. So any member of the Presbyterian Church USA is eligible to have disciplinary proceedings brought against that person. This is not a standard to which we actually only hold ordained persons. This is a standard to which we hold all members of the Presbyterian Church USA. And in days when membership is kind of is sometimes a little more of a foggy line, like we've discussed throughout this class a number of cases in which there might be a long-time participant of a congregation, but they have never joined. A long-time participant who has never joined is not subject to our disciplinary process because they have not joined the Presbyterian Church USA. And that's just how it is. It's not a good thing necessarily. It's not a bad thing necessarily. It's just a distinction we make about our membership.
Is that about them never having taken the vows?
That's not even about them never having taken the vows for ordained ministry, right? That's about them never submitting to the discipline of the church. So the fourth question, when someone is being confirmed, or believer's baptism, like an adult baptism, or someone is joining a Presbyterian church by reaffirmation of faith, is do you promise to participate in the prayers and the fellowship, and I'm gonna have to.
Oh, those are the vows I'm talking about. More
Okay.
like kind of do you submit to to pray for the peace, unity,
The impurity of, yeah.
All of that. Is it like because you never vowed that, then the standard is kind of held differently?
Yeah. So if you have never answered these questions that I've just pulled up on our shared screen, the last of which is, will you devote yourself to the church's teaching and fellowship, to the breaking of bread and the prayers? So there's not actually anything explicit about discipline in there, but by agreeing to this fourth question, in the case of reaffirming the baptismal covenant, or receiving a believer's baptism, or making one's first public profession of faith, or joining at all. By agreeing to this, you are agreeing to be subject to our ecclesiastical discipline. So yeah, these are the oaths that you were talking about, Morgan.
Yeah, thank
Yep.
you.
Yep, absolutely. And so normally, this is just a little bit of an aside, but when I do a child's baptism, where the child is old enough to answer these questions, but the child is not old enough to, say, have been through the process of confirmation. So really anybody between kindergarten and 5th, 6th grade in there, I ask them the first 3 of these questions, but I do not ask them the 4th question. And this is just my personal practice. And I do discuss these questions with the child ahead of time and make sure that they understand what they'll be answering, and that they also feel that they are not yet ready to answer this 4th question. But I feel like there's a lot more personal responsibility accepted in this 4th question, and a greater commitment to how one will conduct oneself as a member of the body one is joining. And for me, that's a question that a believer makes, that a catechant makes, someone prepared for confirmation, that an adult is capable of making on behalf of a child, but not that a child is necessarily ready to make for themselves. And different kids are ready for this at different phases. You might have a particularly precocious 2nd grader who is actually entirely capable of making this promise in all of their 2nd gradiness. Go for it. This is just my my practice. It's not a rule. I and not the Lord say unto you.
I have a question.
Yeah, go for it, Johnny.
Does this same line of thinking apply to affiliate members? Because they're technically not members of the PCUSA, but PCUSA, according to the Book of Orders, holding their certificate of membership.
Yeah, so an affiliate member whose primary membership is with a congregation that is not in the PCUSA, but someone who has asked to affiliate with a PCUSA congregation, is still subject to our discipline.
Cool, thank you.
Because yeah, they've taken that proactive step, and they've probably committed to these questions in some form as a part of that affiliation. More often, affiliate members are already a member of a different PCUSA congregation, but of course that's not universally true. Any other questions about this? Okay, I'm going to return us to my slideshow. So, the disciplinary process provides for the accountability of individuals to the church. That's the biggest difference between remedial and disciplinary cases. Disciplinary cases apply to individuals, remedial cases apply to councils. When it is alleged that trust is broken by an individual, it is important to restore that trust within the community of faith. That's at the heart of any disciplinary case. Trust has been broken by an individual. And through the process of the disciplinary process, we seek to restore that trust within the community of faith, which also means that disciplinary cases are not just about the accused and the accuser. Disciplinary cases are a matter for the whole church. And especially in cases where an abuse of authority has taken place, really of any kind, that need for the restoration of trust is just that much more necessary and obvious, I think, in the process. And this circles us to the purpose of church discipline. Church discipline, as we've already heard, it is not punishment. Rather, it is the exercise of authority given by Christ, both to guide, control, and nurture the church's members for the correction and restraint of wrongdoing. So that word nurture should remind us of that 3rd note of the Reformed Church and the way we interpret that for the church today. And this is also a really important reminder that when we engage in a process of discipline, we are acting for the church with the authority given by Christ. This is no light matter to enter into, and disciplinary cases should not be treated lightly or flippantly. It should not be undertaken casually. But when a council acts in a case of church discipline, that council is speaking with the authority of Christ in that matter. And that is a very grave responsibility. Easter puns are welcome at this time. All right, so the purpose of church discipline to continue is to, we get this reiteration of everything we saw in D-1. So this should also, this practice in the Book of Order of laying something out and then it shows up again later. This should be really familiar to you all by now, because by now you have, congratulations, all read the entire Book of Order. So we get the purpose laid out again. We saw it in D-1. We've talked, the Book of Discipline covers remedial cases first, and then, just as I'm doing, turns its attention to disciplinary cases. So it reiterates the purpose. So back to vocab lessons. An offense. So remember, in a remedial case, we had a complaint. In a disciplinary case, we have an offense. An offense is any act or commission by a member of a congregation or minister of the word and sacrament that is contrary to the scriptures or the Constitution of the Presbyterian Church USA. So remember, remedial cases are only acts, delinquencies or irregularities, sins of commission or sins of omission with regard to the Constitution. Disciplinary cases can be any act of any offense which is an act or an omission that is contrary to Scripture or the Constitution. So that really opens the book as to what qualifies as an offense. So when someone wishes to bring disciplinary charges because of an offense, they make an allegation. Again, technical term. An allegation is a written statement of an alleged offense or offenses, and facts which, if proved true, would likely result in censure. So an allegation is, again, not a light thing. This is the first step. And a PJC or a session will hear an allegation. And much like in a remedial case, there will be this preliminary, oh crap, what's the term? Preliminary ruling about whether or not the allegation is grounds for charges. And there will be an investigation, and then if the basis for bringing charges is found, that's kind of the next step. But allegation is an important piece of that. Who may file an allegation? This is any member of the Presbyterian Church USA. So just like the discipline applies to every member, any member is also eligible to file a written allegation against a member, against any other member, right? This is our church discipline, so this really only applies to, you can only charge people who are subject to our discipline, members of the Presbyterian Church USA. But any member of a Presbyterian Church USA can file a written allegation. And here's another really important piece. Anyone who is not a member of the Presbyterian Church USA may request that a member file a written allegation on their behalf. So let's say that a group, something untoward occurs on a youth trip where one of the youth is not a member of the congregation, and yet that youth is making an allegation. That youth's allegation needs to be heard, needs to be filed. And it is incumbent, I would say, upon a member of the Presbyterian Church USA to file that allegation on behalf of that youth. But this is true for anyone of any age in any situation in which trust has been broken. So remember these longtime participants who aren't members? The way our polity plays out, those folks are not eligible to file a written allegation. But anyone who is a member of the congregation may do so on their behalf and should, because any allegation that is serious enough to be made in writing needs to be made even if it's not from a member of the Presbyterian Church USA. Make sense? All right. I am mindful that we are halfway through class and it is time for a break. So I want to give y'all 15 minutes to stretch your legs, get a glass of water, use the restroom, whatever you need to do. And we will regather at in 15 minutes at 8:18. So we'll break here and I will see y'all back in about a quarter of an hour.
Reverend Marilyn, you're muted.
Yep, I was figuring that out. Thank you. So let me I'll show. I'm gonna go back to all right. Current slide. All right. I hope everyone had a good break. So we have more terms to get through. Beginning with vindication. So disciplinary proceedings or vindication falls rather under disciplinary proceedings, but it is not actually a disciplinary case the way other disciplinary cases are, because it basically deals with situations of rumor, gossip, and impugned reputation, that sort of thing. And it can address things that start within or without the PCUSA. So in D-7.0202, we get a little bit about what this looks like and initiating a request for vindication. So a member of the Presbyterian Church USA who feels injured by a rumor or gossip, which is from an unidentified source, or is from a source not accountable to the Presbyterian Church USA, may request an investigation for the purpose of vindication. So this is not a disciplinary proceeding. This is asking for an official disciplinary proceeding for the purpose of clearing a name. So it does involve our disciplinary process, but it's not because the person is bringing a charge against any specific individual. Does that make sense? So let's say rumors start going around about something that went down at the youth trip. But no allegations are made, nothing is filed, but now the youth director who was on that trip feels that their name has been besmirched because they think nothing happened. They know nothing happened. They did not conduct themselves inappropriately in any way. And yet something has happened that makes things have been said that are not precisely traceable, that make everyone think less of this person, right? This would be a case where a request for vindication would be appropriate. So in this case, a lot of the disciplinary processes will be followed, but with the purpose of clearing someone's name, and not with the process of finding whether or not the charge is founded or not. Does that make sense? This is also how we deal with something that is from a source that's not accountable to the Presbyterian Church USA. So let's say that you're the pastor in a small town. Gee, I wonder what that's like. And a rumor starts about you and the source is another congregation. Let's say rumor about pastor at First Presbyterian Church, Smallville, is started by someone and perpetuated by pastor at First Baptist, Smallville, right? Presbyterian Church has no jurisdiction over what's going on at First Baptist, Smallville. But the professional reputation of the pastor at First Presbyterian Church may be on the line in this situation. And it may be impacting their relationships with their fellow Presbyterian colleagues, even though the source is not Presbyterian. So in this hypothetical scenario, that pastor at First Presbyterian Church, Smallville, might initiate a request for vindication. And then the investigating counsel or the PJC could try to get members of First Baptist to come give testimony. They can't be cited, remember, but they can be requested. And the Presbyterian and the presbytery might try to get to the bottom of whatever this rumor mill is that is so harming pastor at First Pres Smallville. That's a hypothetical example. This is a really important mechanism we have in our church discipline to try to clear a name. And it might, the process of requesting vindication and the process that unfolds after that, the investigating committee might end up bringing charges. If there's someone who's been found to a specific individual who's under the jurisdiction of the Presbyterian Church USA, who's been found to be perpetuating the rumor, or the gossip, or the malicious, slander, right? So that would be entirely an appropriate outcome of an inquiry or a request for vindication, right? But at the beginning, because the source either isn't Presbyterian or cannot be identified, it doesn't start as a more traditional disciplinary case. Does that make sense? It might lead to a disciplinary case, but it doesn't start that way. Okay. Reference. Reference is a really important mechanism we also have within our disciplinary practice or process. And a reference is when in a disciplinary process, a written request made by a session or a permanent judicial commission of a presbytery or a synod to the permanent judicial commission of the next higher council to assume jurisdiction for the case. Okay, so let's say a session is trying to deal with a disciplinary case where allegations have been brought against a session member, and the session just feels totally out of their depth, right? They do not know what they're doing. They're really struggling to figure it out. And it's trying to work through this process themselves as a session is in fact causing more harm than good for their ability to carry out their job as a session and to guide the congregation and all of their other responsibilities. A session could ask its presbytery to take over the case, could ask for a reference, to refer their case to the presbytery's PJC, Permanent Judicial Commission. Now, a presbytery can accept the reference or not. So upon receipt of a request for reference, the stated clerk of the higher council transmits the request to the PJC, and they do one of those preliminary decision hearing things again where the PJC decides what action to take. They can accept the reference and communicate that to the lower council. So in the case of the presbytery in the session, the presbytery can accept the case, the reference. But they can also decline to accept the case and return it to the lower council, but they must state their reasons. So it's really inappropriate to just say no and not say why, right? So a PJC might turn around to a session and say, we think that you need for the restoration of trust in your congregation, you as the session need to be seen to be carrying out this investigation and making a decision and holding one another accountable. But we will help you work through the process so you're not doing it on your own. We won't take the case, but we will help you, right? Does that make sense? That might be a reason why a PJC declines to accept the case. So while and this is just another little detail, while a request for reference is pending and until the higher council that the reference has been sent to acts to accept or decline the reference for the case, any pending deadlines or periods, and there's a whole lot about deadlines in here, and we haven't touched on that tonight, but trust me, there's ink spilled on deadlines. Any pending deadlines or periods of time for action by a council, a party, or an investigating committee are suspended. So if you're trying to kind of kick it up the chain of command, as it were, or send it to a higher council, that just puts a pause on all of the proceedings for the lower council that's trying to deal with whatever the disciplinary situation is. Make sense? And a council can request a reference a lower council can request a reference more or less for any reason, but a higher council doesn't have to accept those reasons. They can send it back down to the lower council and say, sorry, we're not going to take this case, but they need to say why. Does that make sense? Okay. So there's a process of reviewing. Reviewers are a special committee of 3 persons designated by the Permanent Judicial Commission's moderator. They review any petition for review of the procedures of the investigating committee while the investigation in a disciplinary case is in process. They review any petition for review of the decision not to file charges. They determine the need for administrative leave, and they shall not take part in any subsequent trial. So anytime any party involved in a disciplinary case submits a petition for review, and there are a lot of reasons why you might, then the reviewers sort of step outside of the judicial process. If the reviewers were on the PJC, they now no longer can serve on the PJC as it pertains to that particular trial, because they're now supposed to be sort of this independent oversight body to look into matters when there's been a petition for review at any step along the process of the disciplinary proceedings, and render a judgment. And the accuser or the accused can submit a petition for review. And again, that pertains to procedures of investigating, decision to not file charges, determination for administrative leave. So those are pieces that might come up during the process of during a disciplinary process. So we have some checks and balances even built in within a specific level of council. So instead of a council submitting a reference to try to send it up, a council might try to overcome some hiccups in the process by creating the special committee of reviewers. So again, just like in remedial cases and disciplinary cases, there is counsel. Counsel is representation, but there are a couple of other roles that are available in disciplinary proceedings that are not in remedial cases. And the first is an advocate. So in addition to a counsel, a representative, someone think someone like an attorney, but it doesn't have to be an attorney and it doesn't have to be a paid person. It does have to be a member of the PCUSA, however. So just like you might have counsel present with you throughout a disciplinary process, especially at the point of trial or during any meetings of the investigating committee throughout the process, you might also want an advocate present. An advocate has a very different role from counsel. Even though, of course, many languages, the word for attorney sounds like advocate, right? Any Spanish speakers in the class? You know, abogado sounds like advocate to my ears anyway, and that's the attorney role. But for our purposes, an advocate provides support, consultation, and pastoral care for the accuser, those alleged to be harmed, or those accused. An advocate does not need to be a member of the Presbyterian Church USA. This is a very important distinction between counsel, which must be a member of the PCUSA, and an advocate who does not necessarily need to be a member of the PCUSA. So an advocate could be anybody. An advocate could be a friend, a family member, a confessor, a spiritual director, a fellow ordained member of the Presbyterian Church USA, your, best friend since second grade, right? An advocate can be anyone who will be there to support you, care for you, and can consult, but that's not necessarily their primary role, and they're not counsel. Okay, it's an important distinction. Finally, mediator. Mediators are not a compulsory part of our disciplinary process, but since since there's a lot of provision in our book of in church discipline for trying to find other means of resolution beyond that are not our disciplinary process. Mediators are one way that we might try to work through this, find healing before it gets to that point, right? Mediators, if utilized, should be persons known for calm, wise counsel, qualification of diverse cultural competence, especially, and this is my aside, especially in any case where there's a diversity of cultural experience present in the case, okay? And they need not be attorneys or certified mediators. Mediators need not be members of the Presbyterian Church USA. However, they should be familiar with Section D of the Book of Order. It would be very hard to mediate a case on behalf of accused and accuser and accused and an accuser in the PCUSA if you do not understand the book of church discipline, right? Our church discipline. And presbyteries may identify in advance potential mediators. So a presbytery might come up with a list of person or persons who they feel meet these requirements of a mediator, a person known for calm, wise counsel, right? Any fees for mediation shall be negotiated in advance and paid for by the Council of Jurisdiction. A whole lot of ink is also spilled in the Book of Order on jurisdiction. So in any case where the short version about jurisdiction is that in any case where multiple councils might be involved, whatever council in which the case originates, that's the council of jurisdiction. Does that make sense? Okay. So we lifted up in our conversation at the beginning of class that there's a lot of very specific attention paid to situations of sexual abuse in the Book of Order in church discipline. And the Book of Order specifically defines sexual abuse as any offense involving sexual conduct in relation to any person under the age of 18 years or anyone without the capacity to consent. And as an aside, that can be at the time that the abuse occurred or someone who just simply does not have the capacity to consent. So think perhaps an adult over 18 years of age, but without kind of normal mental ability. Make sense? And any person when the conduct includes force, threat, coercion, intimidation, or misuse of ordered ministry or position. Okay. So it is sexual abuse if a pastor makes a pass at a parishioner and there is any inkling that that pastor's sexual advance is that the pastor expects a positive reception of their sexual advance because they are the pastor. That's kind of the case. That's a type of case that this is trying to cover. Does that make sense? I'm sure you've heard of a whole host of cases. I could regale you with many anecdotal stories when pastoral authority has been abused for the purpose of seeking sexual gratification. And those are cases of sex abuse, according to our Book of Order. Period. End of story. Sexual abuse is contrary to the scriptures and the Constitution of the Presbyterian Church USA and is therefore always an offense for the purpose of discipline. Sorry. So, and what I have put in italics here is in italics in the Book of Order, not just bold, in italics. It is given special emphasis. Administrative leave primarily only applies in cases where there is an allegation of sexual abuse. It is possible that it might be appropriate in other cases, but it has primarily been added to the Book of Order explicitly for use in cases where there's an allegation of sexual abuse. And administrative leave for our purposes in the PCUSA is specifically the cessation of any and all pastoral duties. It does not matter if the person, again, the accused is currently employed. It does not matter if that person is currently employed. If they are put on administrative leave, they may not perform any of the functions of minister of the word and sacrament under any circumstances. While administrative leave is in effect, the minister of the word and sacrament shall not perform any pastoral, administrative, educational, or supervisory duties and shall not officiate at any functions, such as the administration of sacraments, funerals, or weddings. It does not matter if the accused is currently not employed by a church. The accused may not go with members of a church to bring communion to a person who is facility or homebound. That would be the performance of a pastoral and sacramental duty, and that is not permitted. Okay. The Book of Order also spells out what this means for persons engaged in validated ministry. The effective administrative leave for a minister of the word and sacrament in a validated ministry beyond the jurisdiction of the Presbyterian Church USA. So think a chaplain in a hospital setting, right? Is the suspension of the validation of the ministry until the matter is resolved, which shall be communicated to the employer by the stated clerk of the presbytery. So if allegations of sexual abuse are brought against a pastor serving as a chaplain in a validated ministry, in a secular hospital, their hospital is to be notified that they have been put on administrative leave, and they may not perform now their employment status is up to that hospital, right? But they may not carry out any of their pastoral duties, even though they're doing it like as part of being a chaplain. So it would be really hard to still do one's job were that the case. So our Book of Order has specifically, the church discipline, the new church discipline section has laid out this very explicitly. What does administrative leave mean? A couple of things about administrative leave. After a determination of whether the risk to a congregation and/or to other potential victims of abuse requires administrative leave or other restrictions upon the minister's service, and when considered in light of the nature and probable truth of the allegations, administrative leave may be enacted, again, regardless of the employment status of the minister facing such an allegation. And such administrative leave or restrictions will continue until either the matter is resolved in one of the ways prescribed in the disciplinary process, or until the leave or restrictions are altered or removed by the members of the commission. Accuser. Accuser is very simply the person submitting the allegation, or the person or persons provided for who shall fulfill the role of the accuser in cases where the allegation comes from a source outside the Presbyterian Church USA. So remember how any member of the Presbyterian Church can bring allegations on behalf of a non-member. We still need an accuser to carry out the role through the disciplinary process. And so it's not necessarily the person submitting the allegation. It may be the person submitting the allegation on behalf of someone who cannot. The accused is very simply the person or persons against whom the allegation has been made. And then there's one more term when it comes to who is involved in a disciplinary case, and that's those alleged to have been harmed. So while a person may, of course, bring an allegation on their own behalf, someone may bring an allegation on behalf of someone else they believe has been harmed. And then a disciplinary case would have an accuser and accused, and those alleged to have been harmed. Those would be individuals named in the allegation who are alleged to have been harmed by the offense. Does that make sense? Cool. A charge is a statement of one and only one offense. After an allegation is made, there is a period of investigation, and the investigative committee then recommends whether or not charges are to be brought. So there's a difference between allegations and charges. Okay, both are written statements, but an allegation begins the process. A charge is when the investigating committee has actually found that there is cause here and that there should be a disciplinary case, and then formal charges are brought. So there may be one charge, there may be multiple charges, because a charge is a statement of one and only one offense. Alternative resolution. We talked a little bit about this at the beginning of class when we talked about restorative justice, but there's multiple forms of alternative resolution. And alternative resolution really tries to capture the idea that our disciplinary process is not the end-all be-all of church discipline, and it's not the only avenue to restoration of trust and restoration of the community. So we try to make sure that we, just as a session, for example, may make provision for other ways to discern before they actually take a vote on a particular topic or action. So the disciplinary process may go outside of the literal written disciplinary process and it may try to engage in alternative resolution. Okay. And we as Presbyterians really believe that the Holy Spirit can speak through more ways than what we have provided for in our Book of Order. And so we try to honor that by naming those means. Alternative resolution means by which resolution of the offense, not office. I'll make a few edits before I put these up on Moodle. Resolution of the offense may be secured outside of the process of church discipline. Should be pretty obvious. Alternative resolution may be initiated after the investigation has been completed and the charges have been drafted, but before the charges have been filed. So that's the time when alternative resolution might enter the process. Make sense? An alternative resolution may take one of three forms: restorative justice, which is laid out very specifically and explicitly in our Book of Order, mediation, or other negotiated means. So there's a lot of breadth and depth there. I'm going to pause just to double check that there isn't a question in the chat because I see a couple things popped up. Yes, okay, great. Thank you for your comments, and I just wanted to take a moment to read them. So we lifted up the gift of restorative justice and that there is an explicit process for that laid out in our Book of Order. And it's a process by which both those alleged to have committed an offense, so remember this is before charges have been filed, so allegations are still what's at play here, and those alleged to have been harmed. Remember the distinction between the accuser and those who have been harmed. Restorative justice happens between those alleged to have committed an offense and those alleged to have been harmed. And they seek to restore wholeness of the body of Christ. Okay, so the accuser, if they are not the person who is alleged to have been harmed, may not be a part of restorative justice. They might, but they might not. I want to highlight that distinction and difference. In those instances where the accused will plead guilty and take responsibility for harm done, and those alleged to have been harmed are willing to find outcomes that repair damage and address the reasons for the offense, the investigating committee may initiate a process of restorative justice to bring closure to the persons involved and restoration to the community of faith. Restorative justice may be employed prior to trial. Remember, that's before charges are filed, or as a part of the process of healing after an accused has been found guilty, when the guilty party has had time to accept responsibility and those harmed have had time for personal healing. So restorative justice can also come in after the trial has been concluded, even after censure has been proclaimed. And but once the accuser who has been found guilty and those who have been harmed have healed, then at that point there's another occasion where a process of restorative justice might be entered into. Does that make sense? They're kind of two on-ramps for entering into restorative justice. And the Book of Order specifically states restorative justice should not be employed as an alternative resolution prior to trial. I'm sorry. I haven't gotten there yet. I thought this was something else. Sorry. Okay. So should restorative justice not be employed as an alternative resolution prior to trial? Remember, that would be restorative justice employed between charges being drafted but not filed. The council shall be open to the process at any time if those harmed request and are willing to engage the process. Okay, so that's the third on-ramp, if you will, off of the disciplinary process and into a restorative justice process, right? Restorative justice is not primarily about forgiveness and reconciliation. That's not what it's for. There should be no pressure on those harmed to forgive or be reconciled. It sounds like that might be what restorative justice is about, right? Restorative, it's in the title. But that's not actually what it's about. The decision to forgive or to be reconciled must be made by the participants at their own initiative. And that happens outside, not outside of the church, but outside of disciplinary proceedings. We opened this evening with a liturgy of confession. Forgiveness and reconciliation could absolutely happen through a service of healing and wholeness held in a small manner, kind of as sort of an official offering and receiving of forgiveness. But that's not a disciplinary process. That would be a practice of worship, right? I'll look up. I think I left out something else about restorative justice that I want to lift up. So we are in 716. Could have sworn I read it. Now I can't find it. I may have to circle back. Oh, I found it. It was about a different section. Okay, cool. Now I know what I'm going to talk about. So there are 4 basic questions our process for restorative justice lays out that are really helpful. So remember, in these alternative resolution practices, mediation is another option, and this goes back to when a mediator might be engaged in the process of disciplinary proceedings. Again, mediators and facilitators utilized in this process should be persons known for calm, wise counsel. For our purposes in the PCUSA, they need not be attorneys or certified mediators. Anyone serving as mediator or facilitator must be familiar with our church discipline, and where harm has been done to another person, presbyteries should utilize persons who have specialized training and skills. So maybe we do need a certified mediator. Doesn't have to be, but it might be. Does that make sense? And any mediated agreement, shall include a specification of charges to which the accused will plead guilty together with a recommendation for censure. Other negotiated agreements was the other part of these three paths towards alternative resolution. And other negotiated agreements specifically lays out, this is what I was trying to find just a moment ago, specifically lays out that ordinarily negotiated agreements, which just kind of covers anything that's not restorative justice or mediation, right? Negotiated agreements covers kind of anything else that's an alternative resolution. However, and our Book of Order states ordinarily negotiated agreements should not be used to resolve allegations of sexual abuse. Okay, so I wanted to lift that up as we think about cases of sexual abuse and what the Book of Order has to say specifically regarding such cases. Negotiated agreements, which is typically something that an investigating committee has sort of prepared as part of an alternative resolution. So it is not a process that has followed the restorative justice process, and it is not something that a mediator has been involved in. It will not be appropriate in cases where there's been sexual abuse. All right, final definition. Censure. So what happens at the end of a disciplinary case when someone has been found guilty? Well, we censure them. There are 3 degrees of censure: rebuke, rebuke with supervised rehabilitation, temporary exclusion from service of ordered ministry or membership rights, and removal from ordered ministry or membership. So a person may be, an outcome of disciplinary proceedings may be that someone is removed from the membership of the Presbyterian Church USA. So remember how when we talked about membership, the only grounds on which you can refuse someone membership in the PCUSA is on grounds of profession of faith. But there's a caveat to that. A congregation can also refuse membership on the grounds that membership has been removed as a form of censure in a disciplinary proceeding. So let's say a member is removed from membership rights because they have been found guilty through a disciplinary proceeding. So not a minister of word and sacrament, but a member, although a minister of word and sacrament could also be subject to this. And that person then moves or, starts attending a different congregation, a different presbytery, and asks to join. And that session should say, well, are you an active member in good standing in another Christian congregation? And if they try to get a letter of a certificate of transfer from the previous congregation, it is incumbent upon that previous congregation to say, this person has been removed from membership as an active censure. We cannot furnish a letter transfer. And a PCUSA congregation should not then enroll that person in membership anyway, because their disciplinary proceedings prevent it. Only the censuring body may enact restoration. Okay? So if a session as an active censure removes a member from membership rights, only that session can restore that person's membership. Does that make sense? Now, of course, that can be appealed to Presbytery, Synod, General Assembly, PJCs, but it's the initiating council for the censure that has the right of restoration. Whatever the censure is, it is never given with malice and vindictiveness, but in Christian love, to offer correction in error and restoration of the community. So if anyone ever asks you, do Presbyterians excommunicate? The answer is, we have a way to do so. Excommunication, that is removal of membership, is in fact a part of our disciplinary process. That may be a form of censure. That is the most serious form of censure, but it can occur. And that form of censure might be chosen for the sake of the restoration of the community and the restoration of trust. And it is possible that an individual's membership must be forsaken for the purpose of the reconciliation and restoration of the community as a whole. Okay. So I wanted to lift that up. Censure is about the accountability of an individual to the church and should not include names of persons who have been harmed. Censure must be made publicly at a meeting of the council or congregation of which the member being censured is a member, and the council having jurisdiction over the member. So remember how I said a whole lot of ink is spilled on jurisdiction and who has it in the Book of Order? It might be that in a case where allegations are made by a member of a council that does not have authority over the person against whom the allegations are made, it might be appropriate for a censure to be proclaimed in the council where the allegations originated, and also in the council where the accused is a member. Does that make sense? Think about the case where someone is engaged in ministry outside of the jurisdiction of their presbytery with the permission of their presbytery and the presbytery within which they are laboring, right? This Dr. Yu ministers as a faculty member at Columbia, which is within Greater Atlanta, but he is a member of Cherokee Presbytery, right? I'm going to pick on you because you're here, Dr. Yu. If disciplinary proceedings were to be brought against Dr. Yu, and I use this as an outrageous example, right? It might be appropriate for a censure to be proclaimed both in Dr. Yu's presbytery, Cherokee, but also in Greater Atlanta to let folks in Greater Atlanta know how this issue was resolved, because if it happened in Greater Atlanta. Does that make sense? Yeah, we hope that never happens. We're always going to behave with the utmost honor and dignity and work for the building up of the entire church, right? But thank you for letting me use you for that example. So censures, remember when we talked about the form of government, about reasons for a congregational meeting or reasons for a called congregational meeting? Proclamation of censure was one of them. So a proclamation of censure might be made against a member of a congregation in a hearing of the congregation at a stated meeting of the congregation, or at a called meeting of the congregation for that purpose. Okay. And the same thing at the level of Presbytery, Synod, General Assembly. But this most often happens on the floor of Presbytery because it is censure against a minister of Word and Sacrament or commissioned ruling elder or ruling elder serving in an office of the Presbytery. And so it would need to be heard at that level. In cases where it's just a rebuke, the censure is a rebuke. The censure is complete upon pronouncement. So if someone is rebuked for their behavior, it's just a public profession that so-and-so did a thing and we're rebuking them for it. That's not funny. I'm sorry. My husband was making faces at me as he was walking through the content. We have a template for how to engage in a formal rebuke in the Book of Order. So this is in the second to last section of the Book of Order, section D-9. We have, you don't have to follow the form of rebuke that is included in the Book of Order, but it certainly makes it easy, right? It is literally a fill in the blank kind of situation. The next level of censure is rebuke with supervised rehabilitation. So this is when just saying so-and-so did a thing isn't enough. But again, rehabilitation is specifically for the purpose of restoration, right? We're trying to give the person or persons involved the opportunity to re-enter the fullness of the life of the church and to rebuild trust. So all censure should occur with this idea that for the purpose of the restoration of the community and the restoration of trust. All right. Thus endeth the vocabulary lesson. We've got 25 minutes left of class. We have a mock session group assignment that I'm going to break you out into breakout rooms for. But what I'm going to do is before I do that, I'm going to invite Dr. Yu to take over for a few minutes. And then I'm going to put you in your breakout rooms and for your mock session assignment. And whenever you are done in your breakout rooms, you are done for the night. Make sense? Okay, Dr. Yu, over to you.
Hey, thanks, Pastor Marilyn. So I wrote it in the chat. So it's more what we're going to do the week after midterm week. I think Pastor Marilyn will say more about the midterm, maybe before the breakout, maybe. But so the Thursday after March 21, we're going to meet directly at the Columbia Seminary Library at 6:30. When you go to the library, you'll see instructions on how to get upstairs one floor to the from the main floor to the client archives. And so we'll get an orientation to the archives for your final project. And then I'll do a brief history lecture there too, alongside the archivist. And then you see it there. And then that'll be until 8. So the library is going to stay open 1 hour longer than closing time for our class. And then we'll take a 15-minute break, maybe a little bit more, give time to walk back over to our normal class room. And then, yeah, and there you'll have Pastor Marilyn going over, hopefully, the good news of your polity midterm exams. And then it'll be definitely, depending on your perspective, either the good or bad news of more history with me. So that's what I want to share in terms of how to get ready for the week after midterms. And I'll write this all on announcements and it'll go to emails to all of us. Thanks.
Thanks, Dr. Yu. So I have a couple of just FYIs about the midterm. It will go live around noon tomorrow, possibly earlier. But remember, right now I'm on Central Time, so that is actually 1 p.m. y'all's time. So the format of the written exam, polity exam, is going to be very similar to polity exam for ordination exam for the Presbyterian Church USA. That exam has 3 questions, which you must answer in 3 hours. My exam will be 2 questions, and you will have the time limit of 3 hours. So do not start your exam on Moodle until you have 3 hours that you can set aside uninterrupted, because if you are interrupted during the course of those 3 hours, your clock keeps counting. And you can try to reach out to me and we can try to figure out an accommodation, but I really don't want to have to do that. So please find a time to set aside 3 hours. And if you are planning to take the Presbyterian's polity ordination exam, I strongly encourage you to set yourself the time limit of 2 hours. Because I'm going to give you 2 questions because you've all already answered for me at least 1 question in your oral exam. But your polity exam will have 3 questions in 3 hours. So I really encourage you to try practicing answering my polity questions, the 2 written questions, in 2 hours, because that'll give you a better sense of whether or not you're really prepared to take the ordination polity exam. Make sense? But that's where some of the grace comes in. I am going to give you the full 3 hours for just 2 questions, and hopefully that will work well for you. It is open book. So I expect you, unlike for your oral exam where I did not expect you to provide citations or quotations or alphanumeric references of any kind from the Book of Order. I just wanted to get a sense that you knew what's in there. For your written exam, it is open book, and I do expect you to provide written citations and quotations from the Book of Order. Your questions will tell you how many citations are required. And I will be grading this and giving you feedback as if it were your PCOSA ordination polity exam. So I'm going to tell you right now, your polity ordination exam, if you do not meet the citation requirements, it does not matter how well you answered the question, you will fail. It's not fair. It just is. I'm sorry. I wish I could fix it, but that's how it is. So I don't want to fail anybody. Please make sure you include the right number of citations. There will also be a word limit. That word limit per answer will be in, you will actually have to turn in your answers in the Moodle submission. You can't upload a Word document this time or a PDF. I encourage you to write and save your answer in some kind of word processor, not on Moodle. And then copy and paste it into Moodle and make sure it fits within the word requirement. The word count for the there is a word count for your ordination exam, so there is a word count for your exam for me. Okay. You will all have the same questions, the same two questions. You may not discuss this. This is not an this is not an open community exam. Make sense? You are responsible for adhering to the code of conduct of CTS and open book, but not open community, just to make that very clear. You may start your polity exam anytime between when it goes live tomorrow and when it is due, Tuesday, March 19th at 11:59 p.m., I think is when I said it will be due. So I expect you to take it sometime next week, but you could conceivably start it as late and still have the full time limit of 8:59 p.m. Tuesday, March 19th, right? 9:59, 10:59. Yeah. I wouldn't wait, but you could. Okay. So do you have any questions for me about the format of the exam or anything like that that I might can answer without actually telling you what your questions are going to be?
Are you looking for an essay style or more like a conversational voice while we're writing? What's the format, like the tone that you're expecting in our answers?
Yeah, so partially the tone that I expect in your answer will be based on the question. So for example, if I ask you to answer as a moderator of a session to a session, I'm going to want you to kind of have like a prepared statement type tone. If I ask you like a polity question, like explain to me this concept from the Book of Order, that's going to be more essay style. If I ask you to provide, an outline or a plan or like a lesson plan or something, then again, kind of adjust your style to what is asked. Does that make sense? So, and it may be two different styles for a different style for each question. The important thing there is to answer the question asked, however you feel best you are able to do that, and make sure you include the right number of citations. Any other questions you have for me about content? Or yeah, anything about the midterm?
So are you as specific on this exam? I know you mentioned I've never taken a polity exam for disclosure. So I'm curious, before you had to cite like multiple parts of the book from different sections. Are we still looking for that same type of citation style of the Book of Worship and Discipline and something else?
Yeah, so your polity, so if the question states that you need to provide X number of citations from at least X number of parts of the Book of Order, you need to do that. If it just says provide X number of citations, they could all be from one part of the Book of Order, but they must all have different alphanumeric designations. Does that make sense? A quotation is not a citation. You cannot use multiple quotations from the same alphanumeric section of the Book of Order and it be considered multiple citations, okay? That's how the polity exam works. I found that out the hard way. So that is what I'm going to expect of you in this exam, and that is what I'm just telling you straight up. That's how this exam works. Does that answer your question, Justin? Okay. And the questions will tell you. If it doesn't say it has to be from multiple parts of the Book of Order, it doesn't. And if it does, it does. Okay. Any other questions about that? Okay, hearing none. I am going to put into the chat because I think you get to take the chat with you when I put you out into breakout rooms. So I'm going to put into the chat the prompt for tonight. It is a discipline question. What else is new, right? So, oh my, what craziness is this? Okay. Sorry, the format just got really wibbly. Let me fix that a little bit. Okay. So here's your prompt. And I'm gonna put you into breakout rooms, and that will also end the recording. So actually, I'm just gonna go ahead and stop it.